to a major decision coming out of an Oregon court today impacting gun rights. That ruling, local governments cannot declare themselves Second Amendment sanctuaries.
Yeah, our Jamie Seymour going beyond the headline site with a closer look at this intriguing legal fight. Jamie?
Today, the Oregon Court of Appeals voided an ordinance passed by Columbia County voters in 2020 that declared any rules about the use of guns to be a violation of the Second Amendment. Now, state leaders say they're going to continue to fight cases like this one in counties across the state. A major blow to gun rights advocates in Oregon as a court decided state laws like gun storage and background checks must be followed in Columbia County, despite the county declaring itself a Second Amendment sanctuary in an ordinance and treating said laws as if they're invalid.
Well, what happens if there's a conflict between how people at different levels of the government think things should be done?
After the ruling, Oregon Attorney General Ellen Rosenblum issued a statement Wednesday about the state's gun safety laws, saying, quote, local ordinances declaring those measures to be unenforceable put people at unnecessary risk and they're illegal, adding that the state's Department of Justice successfully fought these measures in 3 counties so far and will keep fighting them. Lewis and Clark Law School professor Tung Yin says it's important to first look at how the laws work in the state and if they allow any leeway for counties and cities to set their own laws.
At some level, does it make more sense to let the local governments, which maybe are more attuned to their constituents, set the rules that would govern that particular community?
The state DOJ recently fought similar measures in Yamhill and Harney counties that passed forms of pro-Second Amendment ordinances. Yin says cases like these can be compared to the states and cities which went up against past federal immigration rulings declaring themselves sanctuaries. The reason those cases are allowed is because of a U.S. Supreme Court case where federal government can't force states to enforce a federal program, impacting everything from immigration to marijuana laws.
This is, again, a lower level of government, one that's subordinate in a sense, saying, well, we don't agree with you and we're going to do something different.
It's still unclear if there are any court plans for rulings in other Oregon counties with Second Amendment ordinances, and if counties across the U.S. could use this ruling as a national precedent. We reached out to Columbia County officials to see if there are any plans to petition that ruling to the state Supreme Court, but we did not get a response back yet. Reporting live in downtown Portland, Jamie Seymour, KOIN 6 News.